The Supreme Court of the United States convened in full session, the atmosphere dense with anticipation. Though cameras were absent, every legal journalist in the gallery was poised, aware that this was no ordinary Commerce Clause case. The matter, at hand, United States v. Everhart, posed a challenge to federal overreach that could redefine the boundaries of regulatory authority. Justice Amy Coney Barrett, renowned for her strict textualist approach and incisive questioning, interrupted early into the oral arguments. Ms. Bondi, are you asserting that a state executive possesses interpretive supremacy over enumerated federal powers? The courtroom fell silent. Pam Bondi, representing a coalition of states contesting a sweeping federal labor oversight statute, stood alone with a modest stack of notes. She lacked the academic credentials and DC gravitas typically seen in such high-profile cases, yet she remained unflinching. "No, Your Honor," she replied. "I'm asserting that enumerated power does not entitle the federal government to legislate where no judicial test for enforcement exists, and I'm here to propose one." A quiet pause ensued. Even Justice Kagan raised an eyebrow. The chamber adjusted. This was not going to be a routine defense. This was shaping up to be a legal event of significance. Pam Bondi had never aspired to be an academic darling. A former Florida Attorney General known more for her political appearances than for law review publications, she stood now as the legal fulcrum in a case that could realign federalism. Her critics had long dismissed her as a lightweight, a media figure better suited for cable panels than legal precedent. Yet Bondi knew one thing with certainty. The courtroom was not a place of pedigree, it was a place of persuasion. She had spent the past 18 months assembling an alliance of state attorneys general to challenge what she called a quiet federal conquest, the creeping expansion of federal administrative power cloaked under labor and commerce statutes. The target of their lawsuit was the Federal Oversight Act of 2023, a statute that authorized a new federal agency to enforce uniform workplace standards across both public and private sectors. Regardless of state laws, the act was sweeping. Its language was vague, and to Bondi it was unconstitutional. Opposing her was Solicitor General Jacob Reinhold, a Harvard law prodigy and former clerk to Justice Barrett. Reinhold was the legal establishment incarnate. Published in every major journal, praised for his conservative pragmatism and fluent in judicial doctrine, he walked into the chamber with a 50-page brief and a quiet assurance that the justices would fall back on precedent Wickard v. Filburn, Gonzalez v. Reich, and the broader legacy of the New Deal court. But Pam had done her homework. Her argument wasn't rhetorical, it was architectural. She had built what she called the Bondi threshold test, a three-pronged constitutional filter designed to limit federal authority strictly to the text of Article 1, Section 8. The test proposed that for any federal law regulating intrastate activity to survive scrutiny, it must: Number 1, demonstrate a direct and measurable economic impact on interstate commerce. Number 2, identify a historical basis in pre-20th century legislative practice. And number 3, include a judicially enforceable limiting principle. This framework didn't just challenge Reinhold's argument, it bypassed it entirely. Clerks inside the Supreme Court building had begun whispering days before the hearing, "She's not here to argue within the framework." One said, "She's here to replace it." Inside chambers, the justices took notice. Chief Justice Roberts, a proceduralist at heart, privately admitted he was intrigued by the clarity of Bondi's structure. Justice Gorsuch, a staunch advocate of originalism, reportedly requested an advanced brief for overnight reading. Justice Sotomayor, skeptical of state-led challenges to federal power, nevertheless acknowledged the novelty of Bondi's formulation. It was rigorous, it was serious, and it was bold. Outside the court, public opinion was polarizing. Progressive media outlets mocked the challenge as a Fox News stunt in legal form. Conservative journals hailed Bondi as the new Hamiltonian, ready to rebalance the republic. But inside that marble-columned courtroom, such narratives held no weight. Only one question mattered. Would the 9 justices, all products of the most elite legal ecosystems in the country, take seriously the argument of a woman long underestimated? And more importantly, could the Constitution itself, not as remembered but as written, stand up to the modern administrative state? The Federal Oversight Act of 2023 was crafted in the shadow of Silicon Valley, born not from labor unions or public health crises, but from a congressional reaction to a quietly mounting problem: employer surveillance across the country, companies had begun deploying AI systems to track keystrokes, scan facial expressions, monitor bathroom breaks, and even analyze employee voice tone during customer calls. The data was marketed as performance optimization. Critics called it digital coercion. Congress passed the statute with bipartisan fanfare. For the first time, a federal agency, the Workplace Integrity Bureau, would be empowered to set national limits on employer surveillance, override inconsistent state protections, and enforce penalties through administrative courts. But what the bill's sponsors saw as a long overdue modernization, Pam Bondi saw as something else entirely, a constitutional overreach masquerading as workplace reform. This is not about privacy, Bondi told reporters. This is about power. This is about who decides your state legislature or an unelected federal board. Her coalition argued that while the digital tools may be new, the principle was old. The Commerce Clause was never meant to be a license for centralization. Just because surveillance affected employees and employees participated in commerce didn't mean that every HR algorithm suddenly belonged under. Washington's microscope, Reinhold, unsurprisingly disagreed. In his view, the economy had evolved beyond the constitutional boundaries imagined in 1787. We do not live in a fragmented marketplace of tobacco farmers and canal builders, he said. We live in a networked, interoperable, data-centric economy, and this statute merely adapts regulatory structure to modern conditions. The tension couldn't be clearer. Bondi wanted to pull the Constitution forward to restrain modern excess. Reinhold wanted to push law forward to manage modern complexity. What raised the stakes even higher was Bondi's invocation of two past decisions, NFIB v. Sebelius and Murphy v. NCAA. In NFIB, the court famously ruled that the federal government could not compel states to expand Medicaid under the Affordable Care Act. In Murphy, the justices struck down a federal law that barred states from legalizing sports betting. In both, the court drew bright lines around state sovereignty, but were those lines bright enough for the digital age? This is not a question of whether the federal government can regulate the workplace, Bondi declared during a national press conference. It's whether it can do so without limit. Power without metric is power without boundary. If Bondi wins, the ruling could become the most significant limitation on Congress's regulatory reach since the New Deal era. Dozens of federal statutes relying on broad Commerce Clause interpretations, environmental, educational, even healthcare-related, could be subject to re-examination. But if she loses, the precedent set may stretch the Commerce Clause further than ever before. With the court's endorsement, Congress could effectively standardize digital monitoring rules across all states, ushering in a new era of federal technocracy, one in which the judiciary's power to cabin legislation fades into procedural irrelevance. The country watched, corporations watched, privacy advocates, state lawmakers, and civil rights groups watched. And in the background, a larger question loomed not about surveillance or labor, but about structure itself. Who draws the line? And once it is drawn, can it still hold? The courtroom buzzed as the justices settled into their high-backed chairs. The moment had arrived after months of briefs, rallies, and dueling op-eds. It was time to argue the Constitution not on cable news, but under oath and under the lights. Of the highest court in the land, Pam Bondi rose slowly from the table, her legal pad untouched, her expression steady but unreadable. No opening flourish, no preamble. She went straight to the marrow. Your Honors, she began, this statute rests on a noble intention to protect employees, but the power claimed here is not noble. It is total. From the first moment, she staked her case not in sympathy, but in structure. She reached into the recesses of Gibbons v. Ogden, the 1824 case that first defined the scope of the Commerce Clause. In Gibbons, the court recognized federal authority over interstate commerce, but only commerce between states. Not within them. Bondi reminded the court that the line had always existed, even if blurred in the modern age. Surveillance is a workplace condition, she said. It happens inside the state, inside private contracts, inside company policies. The fact that these companies trade across state lines does not federalize everything they touch, Justice Kagan interjected. Ms. Bondi, you're aware, of course, that the court has upheld countless regulations under broader theories of economic impact? Bondi nodded. Yes, but impact isn't the same as authority. And if impact alone justifies federal power, then there is no limit at all. That's not regulation, that's annexation. It was clear from the murmurs and shifting postures that she'd struck a nerve. She pivoted. But let's leave Gibbons aside, she continued. Let's assume for argument's sake that this touches commerce. The deeper flaw is this. Congress created a federal mandate without a federal metric. They empowered a bureau to enforce, but never defined the threshold of what crosses into unlawful surveillance. No test, no limits, just discretion. That's when Justice Barrett leaned forward, elbows on the bench, eyes narrowed. You would rewrite the standard? Barrett asked, her voice sharp, almost incredulous. Bondi didn't blink. No, Your Honor, I would require one. Barrett pressed further. So you're saying enforcement power is unconstitutional unless accompanied by a quantifiable test? Bondi replied coolly. I'm saying enforcement without a measuring stick isn't power, it's presumption. There was a pause. One of those silences that didn't feel like absence, but compression. Something building. Justice Sotomayor spoke next, skeptical. What about intent? Isn't congressional purpose enough of a guidepost? Bondi tilted her head slightly. Intent doesn't enforce itself. Agencies act on authority, not good intentions. If they're allowed to define harm, impact, and penalty as they go, we have regulation by instinct, not by law. At this point, the courtroom dynamic shifted subtly. Bondi was no longer just defending a theory, she was poking directly at the nerve center of the administrative state. Then came the historical hypotheticals. Justice Jackson floated one. Justice Alito layered in another. Couldn't railroad safety standards, passed under the Commerce Clause, also lack fixed thresholds but still hold constitutional weight? Bondi let them finish, then struck back not with new theory, but old precedent. Respectfully, Your Honors, this court resolved that question in 1914. Houston, East and West Texas Railway VI, United States, commonly known as Shreveport. A few heads tilted, a few pens froze. In Shreveport, the court allowed federal regulation of interstate rail rates because they were inextricably linked to interstate discrimination. But it was clear, the connection had to be not just economic, but judicially traceable. That's what made it justiciable. Crossing borders isn't enough. You must cross judicial lines, too. It was a scalpel cut, precise and deliberate. The implication was clear. Modern cases had drifted into abstraction. Bondi was pulling the court back to the concrete. Reinhold's team stiffened. This wasn't the script they expected, and that's where part one ends with Bondi making her first major incision, turning the conversation from economic theory to judicial constraint. The temperature in the chamber had risen not with heat, but with focus. As Bondi returned to her table, there was a brief pause, the kind that happens not out of confusion, but calculation. Solicitor General Kress adjusted his microphone with the measured composure of a man trained never to show panic, but his jaw set just a bit tighter. He stood. Your Honors, Kress began. My friend opposite has skillfully drawn from precedent, but has in doing so drawn the circle too tightly. This law does not require a mechanical threshold. It requires reasonableness, the same standard that governs antitrust, data privacy, and workplace discrimination. He spoke with conviction, familiar ground. And as for the idea that Congress must spell out every measuring stick, I must disagree. Courts have long accepted flexible standards when applied by expert agencies. We trust their judgment, not because it's unchecked, but because its supervised judicial review exists for that very reason. Justice Kavanaugh nodded slightly. Roberts scribbled something, but Bondi showed no reaction. She waited, listening, until Kress said the one phrase she'd been waiting for. This challenge, he said confidently, is ultimately academic. It theorizes a danger that does not exist. The statute empowers review. It does not eliminate boundaries. Bondi's eyes flickered, just for a second. Academic, he, had taken the bait. She rose instantly before he could sit down, interrupting only as a litigator with standing and timing can. With respect, Your Honors, it is not academic, she said, voice rising just enough to slice through the air. And I offer Armstrong v. Exceptional Child Center as proof. The name fell like a stone, a flicker of movement across the bench. Barrett's brows twitched. Thomas looked up. In Armstrong, Bondi explained, this court held that a statutory mandate, even when clear, was unenforceable because Congress had not provided a test or private right of action, a regulation without a remedy. That case wasn't theoretical, it was real, and the court struck it down. She turned to face Kress directly. If enforcement can collapse in Armstrong due to lack of specificity, why should it survive here where even less was given? Kress tried to respond, but Bondi cut again. You asked for harm, Mr. Kress. There it is, a real case where power without structure led to paralysis. And here, we risk the opposite, unbounded enforcement without threshold. Either way, Congress must draw lines. That's when Justice Barrett leaned in once more, but this time not with skepticism. Then show us your test, she said. It wasn't an attack. It was a challenge. Not rhetorical, actual. The courtroom froze. The kind of pause where even the reporters stopped typing. Bondi nodded, slowly. She reached down beside her, not to a stack of binders or annotated regulations, but to a single sheet. Of paper, 1 page, she held it up. This, she said, is the test we propose. A 3-part standard. Intent, intrusion, and immediacy. Any federal action under this statute must prove that number 1, the employer had direct intent to surveil personal behavior unrelated to work. Number 2, the method of surveillance intrudes upon constitutionally protected zones of privacy. And number 3, the intrusion occurs without immediate necessity tied to operational safety or compliance. She laid the sheet on the podium. No one spoke. No one moved. Even Kress seemed momentarily disarmed, unsure whether to argue, absorb, or retreat. The Chief Justice looked at the page. So did Barrett. So did Jackson. The silence wasn't just a pause. It was the weight of structure entering a courtroom full of theory. It was one sheet, but it drew lines where Congress hadn't. And Bondi had just handed them a measuring stick. It took just 90 seconds. 90 seconds for Pam Bondi's 3-part test to redraw the legal battlefield, not in abstraction, but in full color and motion. Where earlier arguments had meandered through doctrine and deference, Bondi's structure, intent, intrusion, immediacy, provided what every justice hungered for. A line that could be seen, debated, measured. Her voice had barely cooled when Justice Barrett picked up the gauntlet. Let's say, Barrett began, a federal statute requires large employers to publish employee wage data broken down by gender, ethnicity, and job classification. Would that trigger your test? The question wasn't a curveball. It was a missile aimed at the core of Bondi's theory, wage transparency. A hot-button issue rooted in equity, not privacy. Barrett was daring Bondi to overreach, to stumble into a zone where privacy and public policy blurred, but Bondi didn't blink. No, Your Honor, she said crisply, because transparency of aggregate wage data lacks individual intent. It's not behavior-specific, and it doesn't intrude into private domains. There's no immediacy, no surveillance mechanism, and no individualized behavioral target. Barrett raised an eyebrow, intrigued but not persuaded. So, she pressed, you're saying the threshold is behavioral? Yes, Bondi nodded. And not just behavior in the abstract, but personal conduct untethered from employment function. Courts must judge not just that data is collected, but why and how. That's the distinction. Justice Sotomayor leaned forward. But what about biometric badges tracking movement? Surely they meet the intent and intrusion prongs. They might, Bondi allowed. If the badges track location for safety or time logging, that's functional. If they track restroom frequency or off-shift activity, then we've crossed a line. The law, as written, doesn't draw that line. We must. The room absorbed it. One by one, the justices looked at the test again, simple words now alive with consequences. Across the lectern, Solicitor General Kress returned fire. Your Honors, he said smoothly. The brilliance of a 3-part test is also its flaw. It assumes clarity in areas filled with context. Courts aren't engineers. What Ms. Bondi proposes would force litigation into regulatory design. The Constitution does not deputize Article 3 judges as policy architects. He paused, then locked eyes with Chief Justice Roberts. This court has long upheld administrative discretion not to allow tyranny, but to prevent judicial entanglement. That balance should not be rewritten in a single argument. But before the momentum could swing, Justice Elena Kagan cut in tone mild, but her words sharp. General Kress, she said, what troubles me is not the presence of discretion, it's the absence of structure. If Congress authorizes a federal agency to monitor employee behavior, shouldn't the boundaries be judicially reviewable in more than just tone? Kress hesitated, and that pause did more than any words. Bondi stepped forward. In Armstrong, this court held that a statute without an enforcement mechanism was unenforceable. Here, we confront the reverse, a mechanism without a limit. If Armstrong matters, then structure matters. Kress tried to pivot, invoking Chevron, citing historical deference, but the weight had shifted. For the first time, his voice didn't command the tempo. And then it happened. Justice Lee, who had remained silent through hours of oral argument, cleared his throat. "May I ask," he said in a calm, almost clinical tone, "are we regulating behavior or merely delegating it?" The room turned. Lee continued, eyes fixed on Kress. "Because if it's the former, then courts must examine purpose and boundaries. If it's the latter, and we're merely delegating to agencies to define both the behavior and the response, then haven't we vacated the judicial role entirely?" "The blow was elegant and devastating," Kress began. "With respect, Justice Lee." But Bondi cut in, not rudely, but firmly. "That's exactly the question," she said. "And the answer must be judicial. A law without a legal ruler cannot rule." Barrett's eyes narrowed, not in doubt, but in consideration. Gorsuch folded his arms. Kagan nodded subtly, lips pressed. This wasn't about scope anymore. It was about shape. Bondi had turned the Commerce Clause debate into something else, something harder to ignore. A confrontation not over what Congress can regulate, but whether regulation can exist without architecture. Pam Bondi didn't hesitate as the court began, circling her three-part test like wolves around a fire. Her voice, steady but sharpening, held the chamber as she pushed deeper. An identifiable nexus, an adjudicable metric, and structural compatibility, she repeated slowly. Not because it simplifies the law, but because it disciplines it. Congress can wield the Commerce Clause, but it must build guardrails. Justice Barrett leaned forward. But that's the problem, isn't it? You're not just describing how the statute operates, you're prescribing how Congress must think before it legislates. You're asking this court to evaluate legislative foresight. Bondi met her eyes, unshaken. "No, Your Honor. I'm asking this court to evaluate legislative structure. Not purpose, not wisdom, just the architecture. Courts do it all the time. We test the scaffolding of laws, not their intentions." It was Justice Kagan who spoke next, no longer probing Bondi, but challenging the boundaries of the court itself. "This isn't just about commerce," she said. "This is about the metaphysics of lawmaking. You're saying structure isn't merely helpful, it's mandatory?" Bondi nodded. "I'm saying it's constitutional. Because if the structure is illegible, enforcement becomes untethered. And when enforcement is untethered, the people are governed not by law but by enforcement alone." The silence that followed wasn't empty, it was calculating. Kress, cornered now, launched one final counter. But what Ms. Bondi calls structure, others would call shackles. Must Congress now submit an operational manual with every statute? If ambiguity is unconstitutional, then discretion dies, and so does flexibility. He turned to Justice Sotomayor. "Surely the court doesn't wish to police the seams of every congressional command?" Sotomayor's reply was unexpected. "We police the seams every day, General. What we don't always do is demand the seam be visible." It was a quiet blow, one that cut deeper than Kress anticipated. And Bondi wasn't done. She pivoted now, not to Barrett, not to Roberts, but to the full bench. "This case," she began, slowly, "is not just about employer surveillance. It's about the outer edge of legislative power. This court has long asked, what may Congress regulate? But today, I ask, how must it regulate? And if the answer is any way it wants, then judicial review becomes judicial permission." She reached into her binder, pulled a single sheet of paper, and held it up. "Your Honors, this is not a new doctrine. It's a forgotten one." She handed the page to the clerk. It was a printed excerpt from Shreveport rate cases, not the part that lawyers usually cite, but a footnote where Justice Hughes mused, "Commerce implies not just interaction, but intelligibility. When the line cannot be traced, regulation cannot be justified." Barrett tilted her head. Kagan mouthed the words again, softly. "When the line cannot be traced." Chief Justice Roberts finally spoke. "Ms. Bondi, you argue that this statute lacks traceability, that it cannot be adjudicated because its scope is undefined?" "Yes," she said, "because it regulates movement without a map, it surveils behavior without a metric, and it governs private conduct through public ambiguity." Justice Gorsuch tapped his pen once, then twice. "So your real argument is that it's not unconstitutional because it surveils, but because it does so without anchorage." Bondi allowed herself the smallest nod. "Exactly, Your Honor. Surveillance isn't the sin, untethered authority is." Justice Lee. "Always." sparing with words, offered a final, echoing thought. Then we must ask, is a law still law if its limits cannot be located? The question hung there not rhetorical, but real. Bondi gave her closing sentence with the kind of composure only earned through years of political fire and legal war. A statute may cross state borders, she said, but unless it crosses judicial lines, it cannot be called constitutional, and no mandate, no matter how modern, can bypass the structure that gives it meaning. The courtroom was still. For the first time, even Cress didn't rise. He simply sat quiet, reflective, aware that the debate had moved beyond argument and into something deeper. Not just a test, not just a ruling, a reckoning. The courtroom. Doors had barely closed when the first leaks began snippets of the transcript. Echoes of the high-stakes confrontation between Pam Bondi and the court reverberated throughout Washington, D.C. and beyond. The world was waiting, but it wasn't just for the verdict. It was for the profound shift Bondi had orchestrated in the rhetoric of constitutional law. Within hours, headlines began to appear, with many news outlets seizing on a line that would forever be linked to her name, the Bondi Standard, a phrase that quickly entered the public lexicon, with legal commentators and scholars alike dissecting the implications of her three-part test. Identifiable nexus, adjudicable metric, and structural compatibility, but it wasn't just the media that recognized the significance. Within the legal community, her arguments reverberated through academic papers, legal blogs, and textbooks. Bondi had done more than challenge the scope of federal power. She had reshaped the framework by which future laws would be tested. It was a game changer, one that caught even seasoned legal minds off guard. The biggest endorsement came from an unexpected source. Justice Morrow, a former law professor and now a staunch legal commentator, he encapsulated the entire moment with a single impactful phrase: constitutional inversion. His article argued that Bondi had not just contested the limits of the Commerce Clause, but had flipped the script entirely. Where the court had once been hesitant to define the outer boundaries of federal power, Bondi's arguments had injected a necessary rigidity into a previously fluid legal landscape. By the time the court released its opinion, it was clear that the states had won. The ruling came down 6-3 in favor of limited federal jurisdiction. The court reaffirmed the principle that certain regulatory powers must remain within state control. However, this decision was overshadowed by one thing: the Bondi test. Justice Barrett, who had once stood as Bondi's most formidable adversary, surprised many by joining the majority. But it wasn't just her vote that caught the legal world's attention. She penned a concurrence that, in hindsight, felt inevitable. In her opinion, she acknowledged the shifting sands of federalism and expressed the importance of providing clear, workable guidelines for federal regulation. What stood out, however, was her endorsement of Bondi's framework. While I remain cautious in embracing broad tests, I acknowledge that clarity in the regulation of interstate commerce is not only desired but constitutionally required, Barrett wrote. The legal world buzzed. A justice who had earlier clashed with Bondi was now articulating her vision as part of the court's foundational language. Meanwhile, Cress, ever the fierce adversary, had no choice but to concede, in a post-opinion interview, he admitted, "We misread the terms of battle. The question was never about surveillance, but about the integrity of the regulatory structure itself, and Bondi understood that before any of us did." His admission was a moment of grace, a recognition that Bondi's intellectual dominance had irrevocably altered the terms of the legal debate. And then, there was the ripple effect in academia. Law schools, ever sensitive to the shifting winds of constitutional interpretation, scrambled to revise their curricula. The Bondi Standard was immediately added to the canon, a new slide between strict scrutiny and Chevron deference in every constitutional law syllabus. Professors raced to incorporate the framework into their discussions of federalism, administrative law, and legislative power. Bondi's influence on legal education would be felt for generations. The aftermath was more than a legal victory. It was a cultural shift. What had begun as a single courtroom battle over employer surveillance had blossomed into a landmark moment in constitutional law. The Bondi test had captured the public's imagination, and its impact was undeniable. The media circus surrounding the case had come and gone, and the nation's attention began to drift toward other matters. Yet, in the aftermath of her landmark victory, Pam Bondi remained elusive, despite the growing requests for interviews and appearances. Bondi declined every invitation, choosing silence over accolades. To her, the victory itself had already made the most profound statement. There were no grand speeches or public celebrations. Her influence was written in the fabric of the court's opinion, in the sharp clarity of the Bondi Standard, and in the transformation of legal thought that would follow. She understood that her win wasn't for the cameras. It was for history, and history would remember her on its own terms. Instead of attending press events or basking in the spotlight, Bondi took a quieter path. The day after the decision, she made an unannounced visit to the Lincoln Memorial. Standing before the statue of the 16th president, Bondi didn't speak to anyone. Not reporters, not staff, not even her closest confidants. There, in the shadow of Lincoln's towering figure, she reflected on the nature of power and the responsibility. That came with it. She understood, perhaps more than anyone, the weight of her influence and the fragility of constitutional principles. Her quiet visit to the memorial wasn't for show. It was a moment of personal reckoning, a time for Bondi to reflect on how far she had come and the profound legacy she was beginning to shape. Back at the court, as the legal world continued to dissect the decision, it was clear that the victory was more than just an academic exercise. Justice Barrett, who had once been a fierce opponent in the battle, reflected on the case with an air of humility. "We dismiss arguments too easily," Barrett said in a private conversation with colleagues, "not for the lack of logic or substance, but because we are too quick to judge their source." Barrett had come to recognize that Bondi's approach, despite the challenges it posed, was rooted in a deep respect for constitutional integrity and restraint. Barrett's words echoed through legal circles, and in many ways, she had come to view Bondi not only as a legal adversary, but as a model for how legal arguments should be approached with thoroughness, precision, and an unwavering commitment to justice. As time went on, the Bondi Standard found its rightful place in the pantheon of constitutional law. Law reviews, articles, and academic papers began to draw comparisons between her framework and the work of other influential legal figures. Bondi's test, with its sharp focus on measurable power, identifiable nexus, and structural compatibility, was discussed alongside other monumental decisions like Lemon v. Kurtzman and Lopez v. United States. Legal scholars began to view it as a foundational piece in the modern understanding of federalism, arguing that Bondi had achieved what many had thought impossible: a legal test that balanced the need for federal oversight with the essential preservation of state autonomy. In the end, Bondi's legacy wasn't built on the victories she won in court, nor on the strategies she employed to dismantle opposing arguments. Her legacy was grounded in restraint, a steadfast belief that power, if left unchecked, could erode the very foundations of liberty. The Bondi Standard would endure, not because it was a tool of domination, but because it represented a vision of measured power, one that sought to keep the balance between state and federal authority in a delicate, yet enduring equilibrium.